If you get a denial for Social Security disability, or even SSI, either one, the appeals process is the same for both. Typically, there are two types of denials. There is a denial that will indicate that medically you don't meet the criteria for disability, meaning that Social Security believes there's some job in the United States that you could do despite your limitations. But there is also another type of denial, and that is a non-medical denial, where with SSD, perhaps you didn't qualify because you did not have enough work credits, or with SSI, if there's too much income coming into the household, that can make you ineligible for SSI benefits. Typically, there's not a lot that can be done with those non-medical denials. But if you get a medical denial again indicating that you don't meet Social Security's medical criteria for disability, there is an appeals process, and I always encourage people to take advantage of the appeals process. Generally speaking, it is almost always better to appeal than to start over. The downside is just the amount of time that it can take to go through the appeals process. If you receive a denial from Social Security, you have the option to appeal. Generally speaking, it is almost always better to appeal than to start over. You have 60 days from the date of the denial to file an appeal, and if you do not get your appeal filed within 60 days, you typically then will have to start over. If you get an initial denial and you file an appeal within the 60-day time limit, your case will then transition over to a different caseworker who will take a second look at everything and make another decision. This particular level of appeal is called a request for reconsideration, basically asking Social Security to reconsider its initial decision. If that is also a denial, you again have the ability to file an appeal within the 60 days. If you file an appeal to a request for reconsideration denial, then at that point, Social Security will assign your case to an administrative law judge, and you can then have a hearing before a judge who will make an independent review of all of the evidence, listen to testimony from you during the hearing, and then make a brand new decision on your case. If you get a denial on your request for reconsideration, you have the ability to appeal that as well. Again, the 60-day statute of limitations applies at that level as well. If you file an appeal, that will trigger Social Security to assign your case to an administrative law judge. That judge will schedule a hearing, at which point the judge will review all of the medical evidence in your case, will listen to testimony from you, and will make an independent decision based on their own review of the evidence as to whether or not you qualify for disability benefits. If your health is making it difficult for you to continue working, or you have reached a point where you're not able to work because of medical reasons, contact us for a free consultation. We're here to help.